I'm David Lombardo, and you're listening to WCNY's The Capitol Press Room. On today's show, we're checking in with Sandy Berland, Executive Director for the State Commission on Ethics and Lobbying in Government, which is responsible for policing the conduct of state lawmakers and Albany lobbyists. Welcome back to the show, Sandy.
Very happy to be here. Thank you for the invitation, Dave.
Well, when we talked back in February, prior to the state budget being adopted, you were hoping for a boost in state aid to cover some of the upgrades to your technology, but at the time we're facing an operating cut from Governor Hochul, despite her team proposing new fees for the lobbyists that you're tasked with monitoring. You ultimately didn't get that increase. So what does that mean for your planned upgrades to the lobbying database?
It's going to be a real challenge for us. One of the things that we were pushing for was increases in some of the fees associated with lobbying activity. So an increase in registration fees and an annualization of the registration fee. Historically, lobbying occurs in a biennial cycle, and there's been a $200 biennial fee with $100 for second-year registrations. We asked and were successful in getting through an increase in that to $250 a year, with the objective being for that and another thing we were asking for, the ability to adopt regulations allowing us to assess late fees for lobbyists and clients who take their lobbying ethics training late. We got that authority as well, and we had asked, and in our draft legislation had proposed, that at least portions of that additional revenue be applied to our technology needs, to upgrading our technology. We did not get that, or we haven't gotten that so far. We haven't given up. We're going to continue the dialogue.
Well, has anyone reached out from the Hochul administration and said, hey, we are not going to give you this money, but here's some personnel from ITS who we're going to loan you, or here's something else? For listeners, you're laughing, so I'm guessing they haven't been proactively helpful.
We we did not get that call, or if we did, I missed it.
Okay.
Although I'm certainly waiting for it. No, we intend to continue the dialogue. We have not gotten that. We are working, I should say, with ITS as best we can to upgrade what we can. But what we really need are substantial overhauls. Our technology is old. And one of the big challenges is that in order to collect these new fees effectively, we need a sophisticated system, a state-of-the-art system, really, that will enable us to generate bills, to do collections. We don't currently have that capacity. So particularly with respect to the second-year registration fee, when lobbyists are not proactively coming into the system to perform their registration activities and give us a credit card for the fee, we're going to have to reach out to them. And in the absence of a system that's capable of doing that, and the same is true if we're going to be assessing late fees for late training, in the absence of systems that can generate the notices and do collections automatically, we're going to have to assign personnel to that task. And one of the big challenges, we did get the full base appropriation we were asking for. That is going to be inhibited somewhat by the fact that the general salary increase, or the cost of living increase that is going into effect and will start hitting employee payroll soon in New York State, was 50% higher than anybody had projected. So usually, past few years it's been 3%, other years it's been flat. This year it's 4.5%.
Right.
That is going to cost us at least $120,000 this year. That's going to impact our ability to hire people. Next year, it's 4%. The year after that, 3.5%. So over that 3-year period, when we were projecting increases of 3% per year, we're going to have 12% instead. And that will cost us nearly $250,000. And so we're going to be down on personnel, and we will have to, unless we can upgrade our systems, we will have to assign personnel who are doing other important tasks like reconciling the discrepancies we get between lobbyists' filings and their clients' filings, or tracking down and ensuring the accuracy of source of funding filings that we get. Instead of having folks doing that, we're going to have them doing collections. It's going to be a real challenge if we can't manage to upgrade our systems.
Well, this makes me think of this recurring conversation people are having about trying to do more with less by utilizing AI. And the governor herself has talked about using artificial intelligence as a way to comb through rules and regulations in the state that might be outdated and in need of an update. Is your commission using AI in any way, shape, or form?
We are not currently using AI in the traditional sense. We have spec'd out systems. We have been benchmarking with like agencies around the country.
Where do you see potential for using AI moving forward?
We think there's a tremendous potential. The State Information Technology Service has several initiatives underway, slowly rolling out AI-capable vehicles to agencies. We're on the waiting list. We're hoping to get to try out some of these systems, but these are not systems that are going to solve the kind of problem that we're talking about. We need more sophisticated systems. For example, we would like to have a first-pass AI-empowered system that will look at financial disclosure statements as they come in and take a first-pass review of them to make sure they're complete, that folks haven't put arbitrary numbers in zeros, for example. Just catch those kinds of base discrepancies and dig a little bit deeper. Same is true on the lobbying side. We would like to have an AI-empowered system that will take first-pass reviews and help us resolve these discrepancies that have been plaguing us for a while now between lobbyist filings and client filings. Catch those at inception as soon as they come into the system, and not create a backlog where we have to go back every 6 months to manually resolve discrepancies. So yeah, that is our goal, to bring in AI-powered systems, and in any event, base more sophisticated systems than we currently have.
Well, before we move on, let me reintroduce you for listeners just joining us. This is WCNY's The Capitol Press Room, and we're speaking with Sandy Berland, the Executive Director for the State Commission on Ethics and Lobbying in Government. So during the legislative session, state lawmakers did move on bills requiring electronic lobbying files, as well as requiring public candidate financial disclosures to be posted on your website as opposed to just elected officials. From a general public perspective, why should they care about the fate of either of those measures?
They're important measures from a public perspective as well as from an operating perspective for our agency. Electronic filing of all lobbying filings means that those 1,000 or so lobbyists and clients who are still filing paper forms will have to file electronically. That means that their data will be instantly available through our public search query to the public, rather than having to wait until we have personnel who can key the information in electronically. On the FDS side, on the posting of candidate filings for statewide office and for the legislature, by posting those, we'll have them up as soon as those come in. We do a little bit of redacting to take out certain personal information having to do with minor children and the like, but once we take those out, they're posted on our website. Otherwise, individuals have to make FOIL requests for us to make them available, and they do. And it ties up our resources. It makes much more sense to just have those available. We're already doing that for incumbents. We have the authority and the direction and the statute to do that. So it makes a lot of sense, and it's much more efficient, and it will provide, again, quicker, almost instantaneous posting of those.
Well, I want to turn to an issue that has been getting a little notice recently, which has to do with an advisory opinion that the commission put out in response to Attorney General Tish James accepting contributions through the Democratic Attorneys General Association to cover legal costs associated with her criminal prosecution for alleged fraud. You issued an opinion that it would be ethical for the AG to accept those funds for her criminal defense, since you've decided that the contributions coming in through the association don't constitute a prohibited third-party gift, at least under the current setup. So what is it about either the setup or the reason this money is being used that passes sort of an ethical test for the commission?
As we have been informed by DAGA, the process that they use, and it's described in the advisory opinion, for allocating funds they receive to the defense, not only of New York State's Attorney General, but other attorneys general around the country and their staff. The process they use is one that is, in effect, blinded. They have a separate body within their organization that makes the decisions about how much funding to put into the pot from which individual legal fees are being reimbursed or paid. And they also make independent decisions about how much of that pot will be allocated to the payment of particular expenses of individuals who qualify. And there are multiple individuals, we are informed, who are receiving that kind of support from the organization. We are also informed that individuals who are making contributions, cannot earmark their contributions for payment of particular attorneys general or staff expenses. And in addition, if despite the anonymity and those kinds of safeguards, despite those, if somehow the attorney general were to learn somehow that somebody had made a contribution with the intent that it be used for the payment of her expenses, she is required to see to it that any money she's received that might be attributable to that individual's contribution be returned to Denica.
Do you think there's a case to be made for basically writing this advisory opinion or something similar about legal defense funds into state law or the state constitution if we are going to see an increased weaponization, or however you want to describe it, of prosecutors at elected officials?
To my knowledge, there's legislation, obviously, that would have provided defense funding and does provide defense funding.
Oh, I mean, essentially,
those who choose to take advantage of it.
I mean, basically having a statute that writes what you came down with in this advisory opinion, at least the spirit of something like this, that says if you want to get money from a third party, here are the safeguards that are in place, here's what we think makes sense, as opposed to relying more on an opinion like this.
That is certainly always an option for the legislature to codify those kinds of principles. We would hope, if that were to be proposed, that the legislature would be mindful of the kinds of protections that we think are important. The general guidance on those kinds of things has always been, those kinds of contributions and those kinds of allocations, has been that if there's any possibility of the individual recipient knowing who the contributor is, then there has to be vetting of it. We think this system accomplishes that more than adequately, and legislation that emulated that, I think, would be acceptable. But the devil's in the details, and we want to be sure that those kinds of safeguards are there. And again, in this instance, after a good deal of communication with that organization and with others, we're comfortable that there are safeguards in place.
The constitutionality of your office was sort of up in the air as a result of a challenge from former Governor Andrew Cuomo. Now that the work you're doing and the entity itself was ruled constitutional, has it impacted how you're approaching your investigations work at all? Do you feel like you're, I guess, going at full steam in 2026?
100%. We are going at full steam. We were somewhat inhibited during the pendency of that litigation for a variety of reasons, and so it created something of a backlog in the cases that we could actually advance to enforcement hearings. And so we are now working through that backlog, and our investigation and enforcement team is doing a great job and working very, very hard to move those matters forward. And in the coming months, the public will see the outcome of that effort. You've seen some of the settlements that we have published that are the product of that, and there are more ahead.
I mean, that's a tease on par with Stay Tuned from Preet Bharara. Can you give us any more insights into what we should be expecting in the coming months?
I can't. Unfortunately, until until these matters reach culmination, either through the hearing process with the determination against the individual or settlement, we're statutorily prohibited. I'm statutorily prohibited from commenting beyond that. But I can say, and you can see it in the monthly reports that we issue in conjunction with commission meetings, that matters are advancing.
Can you tell us what areas we should be thinking about? Should I be looking to the third floor of the Capitol? Should I be looking down to the second floor, outside this building, somewhere else?
Stay tuned.
And you don't want to play hot and cold with me right now either.
No.
Okay. Well, we've been speaking with Sandy Berland. He is the executive director at the State Commission on Ethics and Lobbying in Government. Sandy, thank you so much for making the time. I really appreciate it.
Again, Dave, thank you so much for giving us the opportunity. Much appreciated.
Support for the Capitol Press Room comes from O'Donnell and Associates, a public affairs firm providing strategic guidance to businesses and nonprofits on navigating policy and regulatory issues. More information is available at o'donnellsolutions.com.